looks in the direction of the intruder into his home. She is an intruder into his home. And before he can even get up, he is shot dead in his own home by her. Okay.
Forgive me. I'm just not really impressed with the prosecution in this case. It's a tough case when it goes to state of mind of the defendant, but a lot of dramatic wordsmithing and all the rest. That doesn't do anything for me, but it may for some other people. He's been with us since day one. Chris Lewis, defense attorney with Crane, Lewis, and Brogdon, is with us once again. And are you surprised at all that it's gone so quickly?
No, like I said last week, in terms of the fact pattern, it's a pretty simple case. Cases always move fast in state court in Texas, and so the fact it went into the second week, I'm a little bit surprised. But you'll see, we didn't have a full day on either Thursday or Friday, and then we had a very short day on Saturday,
right.
And then today was essentially closing argument. So, although it's stretched out into a second week, it really hasn't taken that long.
All right. On day 7, the jury was given instruction by the judge. They then were dismissed to, have lunch and then start deliberation. What do you expect in the way of length of time for the deliberation on this case?
I think especially since the judge allowed in the instruction related to the Castle Doctrine and the judge allowed in manslaughter, I think that is going to certainly, the more things that the jury has to decide, that's going to lengthen the deliberations. If they are of one mind, those 12 jurors are of one mind, it will go quick. I don't think they will be in this case. And I think adding the manslaughter charge, which I do not think the facts of this case support that charge, I think that's going to unduly complicate the issues. And I think that's where the emotion-filled arguments of the prosecution are going to have some effect when the jury decides whether or not this was a manslaughter. I don't think it necessarily works on the murder charge.
I've got a question. Talking with Chris Lewis with Crane, Lewis, and Brogdon, something that I didn't understand. The initial investigation done by the Rangers, they came back with criminally negligent homicide. The jury was given instruction by the judge, murder or manslaughter, that's it. Why were they limited to those two things? I mean, manslaughter, it's reckless behavior. I get all that. But I don't think that the state showed that it rose to the level of murder either. I mean, not based on, I haven't covered every word, but, we've been doing this every day. I don't see that. So I can understand when you say this could really complicate things for the jury. What happened to the recommendation from the Rangers?
Well, you've got to break it down and forget what we've always heard and what we believe about what has to occur in order for there to be a murder. The intentional shooting of another person is a murder. The intentional shooting that leads to the death of a person is a murder unless there's some other justification or defense. So the question is, was Amber Guyger's intent when both of them, Jean, was shot, did she have the intent to shoot him? Was she reckless about it, or was she negligent about it? And I think it's clear that she aimed the gun at him. She intended to pull the trigger. She intended to shoot him. That means that the only crime that should be on the table, there is no recklessness there, and there's no negligence there. It's intent. So the question is, should it be an intentional murder where there is no defense, no justification, or is there a defense and a justification for that intentional act?
Wow. Yeah, I see what you're saying. I mean, I was also surprised to hear her answer the question on the stand the way she did when she said, yes, she intended to kill him. I think everybody took a second look at that. But, here we are in day 7, jury is deliberating. this seems double tough to me. I mean, you're in this business. This is what you do every single day. What do you think the jury is more likely to come back with?
I just don't think it's a murder case. So what you were just talking about, how the prosecutor boxed in Amber Guyger. Did you intend to shoot him? Did you intend to kill him? He had to do that in order to get a murder charge. The only reason they asked for manslaughter is they're trying to hedge their bets. I personally do not feel like there was any reckless conduct here that would have led to a charge of manslaughter. But they wanted to make sure they got a conviction of something, or they increased their odds. I expect there to be a not guilty on murder charge because there should be. I personally believe there's no recklessness that was shown, so it should be a not guilty for manslaughter. But what you've got to know about juries is, despite the law, especially when it gets complicated like this one is, a lot of times you will see them try to split the baby. That's where the arguments of the prosecutor, don't let his life be in vain, don't let his death be in vain.
Right.
A person shouldn't be killed in the confines of their own home when they're engaged in nothing but innocent conduct. It might work when the jury is considering the charge of manslaughter.
But you've explained it pretty well. I don't believe this rises to the level of murder under the letter of the law, as I know it or as I read it. It doesn't appear to be manslaughter either. Could this jury find her not guilty?
The jury absolutely could, and I think they absolutely should. If we are just looking at this from a very objective standpoint, not based in emotion, but based in the facts and based on the law, this should be a not guilty all the way around. But will the jury allow that to happen? I don't know. You are going to have some jurors who are steadfast. The emotional arguments don't work on them. This very well could be a hung jury. That wouldn't surprise me. I would say right now, if I were saying the leaders in the clubhouse, I would say either a hung jury or some conviction of a lesser included offense, which would be the manslaughter. That's the only other one put before them. If you have a jury come back and they're guilty on this, you know that the jury did their job because they listened to the law, they abided by their oath, and they applied the law to the facts of this case. It's just hard for 12 people to do that.
I think you're absolutely correct. You've been doing this a long time, and you know what happens to a city when an unpopular verdict, and a lot of people don't know any more about this than what they see on a headline or, scrolling through Facebook news or something like that. So, if they don't drill down and see the legal ramifications, there are a lot of people in this city that are going to be upset.
There are, and I think I've commented on this before, and I said, well, we've got a jury that's comprised of 10 persons of color, and you have an African-American judge, and this isn't a situation where there's a white judge and a bunch of white jurors deciding what should or should happen with a white defendant. But the more I read comments from social media and listen to people's take, even talking to people in my neighborhood, people aren't aware of the fine details of this case. They're only interested, they only hear and are concerned with the headlines. Innocent man is killed in his apartment by a police officer. And so it does make me concerned about what is the reaction from those that don't know the details, the finer points of what's gone on in this case and the facts that have been elicited.
I can't tell you how much you have helped us, Chris. I appreciate it. Chris Lewis, defense attorney with Crane, Lewis, and Brogdon, and he's agreed. I don't know whether you want me to do this today or not after this segment, but if you have a question, if you have a comment, you can email him directly, Chris, C-H-R-I-S, at cranelewis.com, C-R-A-I-N, Lewis.com, Chris at cranelewis.com. We will talk again, I'm sure, as the verdict comes in. I appreciate it so much.
Yeah, Rick, I appreciate you having me on. It's been a pleasure.
All right, thank you. We'll step aside very quickly. Got a little business to do, then right to your calls.